Hello, everyone. My name is Kelly Nash, and welcome to today's webcast. If not now, when? Achieving Equality for Women in the Courtroom and ADR. This event is brought to you by National Arbitration and Mediation and sponsored by Law.com. Before we begin, let's go over some basic housekeeping items about the webcast console. First, this event is completely interactive and incorporates many of today's social media tools. You can tweet or directly post information to your Facebook and LinkedIn pages right from the console without opening a new browser. Simply scroll along the bottom of the screen and click on the social networking widget of your choice. If you have a question for one of our speakers, please enter it in the Q&A widget on your console. We will get to your question during the event or during the live Q&A at the end, depending on how much time we have. We will answer as many questions as possible, so we invite you to ask away. If we don't get to your question, you may receive an email response after the event. In addition, there are some other customizable functions to be aware of. Every window you currently see, from the slide window to the Q&A panel, can either be enlarged or collapsed. So please feel free to change the look and feel of your console as you'd like. And finally, this event is CLE eligible. CLE has been approved in the states of California, Illinois, New Jersey, and New York only. Participants who wish to receive credits for other states must check directly with their CLE board. During this presentation, the CLE code will be announced. After the presentation, all participants will be prompted to complete an evaluation form, which is optional. There will be an area on this optional evaluation form that prompts attorneys for the code. Only New Jersey and New York attorneys should enter the code. New Jersey and New York attorneys should also be sure to retain the code for their records, since they will need to re-enter it in order to download the CLE certificate. CLE credit is available for attorneys in the approved jurisdictions on the live webcast date, November 28, 2018. 1 week from today, on December 5th, all participants will receive an email with instructions on downloading state-specific CLE certificates. And now for today's topic and the reason you are all here. Conversation around the gender gap in law is drawing more attention in the wake of the Me Too movement. Law firms, corporate counsel, judges, clients, and alternative dispute resolution providers can take a proactive role in addressing gender disparity and moving the needle towards a solution. Here to address how this can be done are the Honorable Elizabeth Bonina of NAM and former Justice of the Supreme Court, Kings County, as well as Carrie Freed. Carrie is Assistant General Counsel at Philip Morris International. So to kick off today's discussion, I'd first like to turn it over to Stephanie Ball, Director of Continuing Legal Education at NAM, in order to get us started. Stephanie?
Thank you, Kelly. Good afternoon, everyone, and thank you for attending our webinar today. We have a very dynamic duo, and they are very versed in this topic, and it's near and dear to their hearts. Our topic today, if not now, when, achieving equality for women attorneys in the courtroom and in ADR, was prompted by the New York State Bar Association report of November 2017. This report of the New York State Bar Association was prepared by the Commercial and Federal Litigation Section Task Force on Women's Initiatives. And the information that we found from this task force was the pipeline is not clogged. Women have represented 50% of law students for at least 10 years. Women prepare briefs, women sit at counsel table, yet women do not speak in court. Women do not get roles as neutrals. And our question is that reality or just anecdotal? Task Force decided to find out and collect actual data. And the task force found from this report that women and minorities are still unequal when it comes to speaking in court and being represented as neutrals in ADR. I'm going to turn this over to the Honorable Elizabeth Benina, who was voted a top 2 arbitrator in New York State in 2017. Judge Benina, will you tell us about your journey to where you are today and how you became one of the 2 top arbitrators in New York State?
Well, thank you very much, Stephanie. It's been quite a journey for me. I didn't go to law school immediately from college, and I instead worked in government. And when I went to law school, I found that it was still a man's world. It was still a man's world. And even though I had great opportunities while I was in private practice to try cases, I still found on occasion that it was still a man's world. And I'll tell just a very short story about something I experienced when I was a young attorney. I was sent on to conference a case to try and settle a case before trial with a male judge, male defense counsel, and I sat down and I'm ready to present my case, and I had prepared really very well, what I thought very well for the conference, and I was asked to go out and get the male judge and the male defense attorneys coffee. I was asked to go out and get coffee for them and serve them coffee. And while they're all chatting it up in the room and I'm trying to get the coffee in the judge's chambers, I didn't think I could say no. How could I say no? This is the judge that I'm asking to help me settle a case. So I went and got the coffee. It was quite an experience. So after spending a number of years in private practice, I was fortunate enough to become a judge. And even as a judge, at the time, there weren't that many women on the bench, at least in Brooklyn. We had some trailblazers, some fantastic female judges, but there weren't, again, we were in the minority. And there were times when some male attorneys didn't take too kindly if I ruled against them. And I can recall one particular experience where a male attorney, when I ruled against him on a motion, he leaned over the bench and he really looked quite menacing to me, and he kept getting closer and closer to me, and I kept backing away, and I kept asking him to back off until I had to ultimately ask my court officer, who incidentally was also a woman, to escort him out of my courtroom. So there are times when men didn't like to hear, that or hear an adverse ruling from a female judge. It was really quite an experience.
Did he come back to your courtroom?
No, I think he sent somebody else after that from his firm. So, I had other experiences too, where in a trial, a male attorney kept wanting to remind me that he knew my father. And my father was a well-known trial attorney, and he kept trying to remind me, and I said, this is really inappropriate. And I told him many times to stop doing that. Ultimately, it took, for him to stop doing that, it took me to have to threaten sanctions and say one more time, and I'm imposing sanctions on you, because this is completely inappropriate. That stopped him. But it wasn't until that point that he did stop. So I just, so women have come a long way since way back then. And here at NAM, of course, when I first started at NAM 11 years ago, I was one of only 2 women on NAM's panel. And NAM is, I believe, tripled or more than tripled the number of women on their New York panel. And NAM has been a leader in promoting women in ADR. And I think that's a terrific thing for all of us.
Carrie, you were a young associate. Can you tell us something about how the difference is, and you transitioned to be in-house counsel at PMI?
Sure. Well, I came out of law school, and, interesting in the report, it talks about sort of representation of women in law school is about 50-50. The law school I went to, about 50-50 as well. I came out of law school, was fortunate enough to do 2 federal clerkships, including for a female judge, which was very interesting to see the way that she handled similar issues that she faced as well in the courtroom. And joined a large law firm as a litigation associate. And it was a firm that was very supportive of diverse attorneys and certainly recognized the value of diversity. But I think that I still experiences the challenges that many people do face, many women do face. And when I transitioned to the in-house role, I think it's made me much more aware of the issues, as well as, from a more important perspective, aware of solutions. and ways to deal with the issues because I was on the other side of it, because I had the situations where, I was asked to go print the things, where I was asked to get the drinks, where I was, reminded to wear a skirt to go to court. I mean, these are, little snapshots and little experiences, but when you've had things like that and you've seen different experiences, when you're then on the other side and you are in a position to have an influence in terms of the lawyers that you select to represent you and then the specific attorneys working on your teams, I think that you bring a perspective as to how to address those challenges in a more head-on fashion. So just a very practical example is when I was at a law firm and I had my first child, I sort of struggled, as we all struggle, with sort of figuring out where the balance lies, if there is such a thing. And because I'm sort of aware of what that's like, when there are attorneys who are working on my teams who are going out, whether that's maternity, paternity, or even taking care of a sick parent, I'm very proactive in talking to the relationship partner and saying, this is someone who I value, it's someone I want to continue on my team. How can I, as a client, help support you in facilitating sort of the best possible transition back to work? And I find that, I had a client who did that for me, and the value of a client coming to the firm and being very proactive, not only talking about the value you bring as a young lawyer to that client, but really how do we continue to support you, I've found at a very practical level is quite helpful.
Judge Benina, how did you, when you were in practicing at a law firm, what types of initiatives did your firm have to promote women?
We were at the firm I was with. First of all, it was a family firm. I have to give that disclaimer. But the women in the firm tried cases. In fact, the firm as it exists today now has only one male partner, and all the other attorneys in the firm, whether partners or associates, are all women. So I think that that's really terrific. But we were brought in right away. First day after being admitted, we were arguing motions. We were sent to try cases. So there was great faith that was put in us, and I greatly appreciated that opportunity.
And Carrie, how did you, as an associate, how were teams formed at your law firm?
I think certainly there was a degree of sort of you're this level associate and therefore you're capable of doing sort of these skills. And I don't think there's anything wrong with that. I mean, as you, particularly in litigation, from the time you start out, as you progress, there is sort of a chronological way that you need to get experience. Although I will say from a big firm perspective, what obviously needs to happen more of, and I think this is across the board, but particularly important for female and diverse attorneys, is getting the opportunities to have speaking roles in a courtroom or an arbitration or even a client meeting really, really early on in your career. Because one of the things that I think sometimes happens, and I certainly see it when I was at the firm as well as now from an in-house perspective, is you as a female attorney can have a lot of strengths in terms of your abilities to, say, organize a team, to supervise a document review, say, to run a work plan and to keep things sort of, the day-to-day, everything running quite efficiently. And that can give you a lot of recognition in a firm, right? Like you can be a very valuable member of the team if that's something that you were able to accomplish. But at the same time, that you might enjoy that work, you might be good at that work, but that's not in and of itself going to make you be able to go to court and speak. However, if you can recognize, and if those supporting you can recognize that if you have the ability to organize your thoughts well and direct a team, that will mean that you likely have the ability to clearly present your case in court and seek to take that same strength and build upon it earlier in the career. I think that would certainly go a ways at addressing some of the issues that we see here today. because I do think the longer you get in your career, particularly from a litigation perspective, without that type of experience, the harder it is to get the experience, and honestly, the more you haven't had the chance to build the skills that you need. And, it can be scary, right? When you go to court the first time, it's just going to get scarier if you're, a fifth-year associate. So I think, that's an area that people need to work on, and I also think that's an area where we as in-house counsel need to do better. I'm a big believer in we need to take a little bit of risk in terms of giving our younger lawyers more of a long leash and an ability to learn from mistakes, and we have to get comfortable with that. But I think you also have to think about how you redefine risk, because there's certainly situations where I've been in where there's been a young attorney, say, going to case management conferences on a regular basis, and there's a big one coming up, and I have certainly had the thought, I can't let her do it. I have to bring in the senior partner because this is like a big deal conference, and what if she messes up? And, then I have to take a step back and say, hey, she knows this file better than anyone. Is it really risky? What's riskier for me as a client? To send in the senior trial lawyer who actually has been paying no attention to this for good reasons, or to let the young female lawyer who knows this backwards and forwards, who already has a rapport with the judge, do the talking? And I think and this applies both in big law firms as well as in-house, we have such a tendency to go immediately to what we think is a safe option without maybe recognizing that we have some implicit bias there, and that maybe actually the less risky option is letting the younger lawyer who really knows this file do the meaningful work.
Judge Bonina, over your time on the bench, did you see an evolution to where more women were getting to present motions to you or to argue their case in front of you?
Absolutely. I definitely saw that from the beginning of time through now, from the beginning of my time on the bench through now, I should say. Particularly lately, I've seen quite a bit, and perhaps I'm noticing it because I knew this program was coming up, and I began to think about it and really pay attention to it. But lately, I've noticed the trend where senior attorneys, whether they're the trial attorneys or the partners, bring in younger associates, men or women, and allow them to question a witness during an arbitration or conduct some of the negotiations during a mediation. And I think that's fantastic. I think as some of the, I speak for myself because Carrie is much younger than I am, but speak for myself, I think that it's, as the older generation, I think we need to help and foster and bring up those who are younger than us and help train them. And I try to be cognizant of that myself when I'm conducting arbitrations or mediations here at NAM.
I thought one of the interesting things about the report in terms of the recommendations that I was not aware of was the recommendations to the judiciary with the courtroom rules or the local rules that they may have. And there are a number of judges who've instituted these rules where women or diverse attorneys, younger attorneys, I think they probably phrase it as younger attorneys, which is the correct way to go, may have an opportunity to argue a motion, whereas normally they wouldn't give an oral argument. And I would say from my perspective as a client, I am constantly in these very frustrating calls where I'm saying, how do we get argument on the motion? How do we get argument on the motion? And the outside lawyer is saying, well, this judge won't do it, or they're too busy, or this or that. And from my perspective, going back to clients and thinking about risk, if I knew there was an opportunity to have oral argument on a motion, if a younger attorney was arguing it, I think there are many, many situations where I would certainly go for that.
Right. And actually, it's interesting that you say that, because part of my preparation for today, I looked at some of the rules of some of the judges, and Judge Jack Weinstein from the Eastern District of New York states actually in his rules, which I have open in front of me, the Federal District Court for the Eastern District of New York is a teaching court. Each year, hundreds of law students serve as externs in the chambers of magistrates and district judges. They are a valuable resource, and through their work at the court learn the basics of federal litigation. Members of the court engage in educational activities. He goes on to say, junior members of legal teams representing clients are invited to argue motions they have helped prepare and to question witnesses with whom they have worked. Opportunities to train young attorneys in oral advocacy are rare because of the decline of trials. Where junior lawyers are familiar with the matter under consideration but have little experience arguing before a court, they should be encouraged to speak by the presiding judge and the law firms involved in the case. This court is amenable to permitting a number of lawyers to argue for one party if this creates an opportunity for a junior lawyer to participate. So I love seeing that Judge Weinstein has adopted this rule in his courtroom, and some others have as well.
We see that several NAM, JAMS, AAA have all taken a pledge to promote women selected as neutrals in ADR. Can you give us your thoughts on that?
Well, I think NAM certainly has done that. As I said earlier, NAM has more than tripled, I believe, the number of women on their panel. For me, it's essentially a full-time job, as it is for my colleague Susan Hernandez and some of the other women on our panel. So absolutely, NAM has done a great job in promoting us and encouraging us to take risks and take on different types of cases that we might not have taken on before. So I think it's really terrific that we've gotten so many opportunities here at NAM.
Well, you certainly have set the bar high for us. Thank you. And Carrie, how do you see the difference now that you're in-house counsel and what your clients are expecting from the teams that you put together?
Well, look, I think that there is, certainly, so when I work with a U.S. law firm, it's clear that when we have the conversation about diversity, they get it, right? They get the fact that having a diverse team is an important thing to us as a client, and they understand the value that diversity brings. I mean, I think that we certainly know that diverse trial teams are better trial teams. That's been sort of repeatedly shown in a number of different contexts. I think it's more challenging on the international side. I do a lot of work overseas, and there the conversations are just starting. One of the really useful things I found from this report that I've actually incorporated now into a couple of these discussions, and it's what you mentioned in the beginning, Stephanie, is that it's not a pipeline issue. And even those who recognize the value of diversity, I think, believe it's still a pipeline issue. And I certainly see that on the international side. And perhaps there's a little bit more of a pipeline issue there for sure. But I think that one of the very valuable conversations that can be had is exactly that, is really this recognition that it's not a pipeline issue. And what that means, if it's not a pipeline issue, is that we all have to make very practical choices in terms of how to make it better. Because it's not going to resolve itself just because of a pipeline. It's not just one day because we're going to have equal amounts of lawyers, female and men, you're going to have equal amounts of people speaking in court. I do think it's interesting, some corporations have moved away from sort of a traditional carrot approach with their outside firms where diversity is one of the very important factors, to more of the stick approach where they have specific metrics. And so a couple of examples are Facebook, who now requires 1/3 of all of their attorneys working on their matters to be women and ethnic minorities. HP has an interesting thing called a diversity holdback, where they will actually withhold up to 10% of payment from an invoice if the invoice does not reflect the diverse team to which they agreed. And MetLife is working with firms where the firms actually come to them and they present for approval their development plan for the diverse attorneys. And so you have, I think some corporations who are saying it's not a pipeline, if it's not a pipeline, what can we do? And so they're starting to implement these very specific metrics. And I think it'll be interesting to see over the course of the next few years, do more companies move in that direction in terms of the stick approach versus the carrot approach and how successful they are.
Carrie, I know you travel a lot overseas. How do you see the difference between outside of the United States and in the United States, how this is being handled?
I think what I mentioned a moment ago about sort of accepting diversity as a value in and of itself and something that makes you, it's not just a good to have, but it makes you a better legal team is not sort of as widespread. But I will say that, it all gets back to these conversations. And I think the If Not Now When report sort of said that the first step in correcting the problem is to identify it. And I've had some experiences with firms in other countries where, for a couple of years we had, during our sort of annual review process, I had the conversation with them about the lack of diversity on the firm generally, as well as on the team that's working on our matters. And I got a lot of sort of, it's a problem for everyone here. It's not us specifically, which they're right. It wasn't them specifically. They weren't sort of out of step with the other firms in their jurisdiction, but that wasn't the answer I was looking for. And so, they actually started something very interesting, which, today in the U.S. is probably just, this was done years ago, where they put together, a working group of law firms and banks in their country, in the big city in their country, and they started just to have these lunch and learns where they talked about it. They just shared sort of, these are the issues we're having, attracting and retaining female lawyers. Are you having these issues? Of course they were. What are some things that we could all do? And coming out of that, they actually put together a plan that's now being used, on a voluntary basis, but still across these law firms and these corporations on flexible work arrangements. And they're so proud of it. And it's like, we went from having these conversations of, well, what do you want us to do? It's everyone, to them feeling empowered that they could start to do things. But they're a long way off. And we're all, this report, it is striking in many ways to show how far off we are in terms of some of these issues.
Judge Benina, how can we prepare women in law schools to pursue a career in ADR?
Well, I think that one of the best ways, something I strongly believe in, is mentoring and working perhaps through the law schools with their alumni to have women be mentored, either by other women or firms in general taking on a few interns and what have you, but truly mentoring them, not having them just do research and writing, but bringing them to court, giving them that experience, and taking a true interest in them. I think that a mentoring program is a great thing. The Brooklyn Bar Association has a great mentoring program, and I'm not familiar with whether others do, but I'm active in the Brooklyn Bar, and I do know that they have a great mentoring program for young attorneys in general, and many women participate in that.
And as being a top arbitrator here in New York State, what do you see? Do you see any pushback when you are being selected for a panel, or other women being selected for a panel? And how do we combat that?
Well, I haven't seen the pushback, but I do sometimes notice that more often than not I'm the only woman in the room. Even this morning, my arbitration I had this morning, I was the only woman in the room. So, I think that it's just an awareness, and as more women become interested in ADR, either as a neutral or in terms of bringing their cases to ADR, we will see more. And I do comment occasionally when we do have a room full with just women attorneys and myself. It's very nice, and it's nice to see that change. And I have noticed it more over the years.
Carrie, can you tell us how we can increase this in in-house law departments?
Yeah, I mean, I think that, on the in-house side, I'd be interested to see what the numbers are. My sort of anecdotal feeling is it's better in terms of just sort of sheer numbers of women in sort of based on the level that they are in-house. I think that the in-house option can be, to be frank, attractive in some ways if you, in terms of sort of the work-life balance. It depends on sort of where you are. I'll put that as an asterisk because, there are lots of in-house lawyers, I feel like myself included, who, it can be on the in-house side just as stressful, if not more, than on the outside side. But I think what I find refreshing on the in-house side is that, believe it or not, again, anecdotally, I feel like when I am counseling the business, I interact more with females on the business side than I may have interacted at a law firm with female partners. And again, that's just a little bit anecdotal on my part, but it would be interesting to look at that from the business versus law perspective to see if there are some actual differences, whether that be in mentorship or what have you, between women in law versus women sort of in an MBA type of a program. However, I will say that, like you, I do frequent meetings where I happen to be the only woman in the room. And it's one of those things, and I've talked about it with some other colleagues, where it doesn't even faze me anymore. I mean, there are times where I just don't even realize it. However, if I'm in a meeting with the majority women, that seems like that's something, right? So, I do think we're getting a little bit better on the in-house side, but, I continue to see challenges there as well.
Well, we're going to pause for Kelly to give the code.
Yes, thanks, Stephanie. So at this point, we will go ahead and announce the CLE code. The CLE code is equal 28. That's EQUAL 28. Again, the code is equal 28. I'll turn it back over to you, Stephanie. Thank you.
Thank you. Judge Bonina, what do you think about the judges being surprised by the results of this report?
Well, I myself was a little surprised, and again, to use the word striking that Carrie used earlier, it is striking to see that such small percentages of women made up, whether it was the trial level, the appeal level, parties of 2, and dropped down significantly to parties of 5, 19.5% were women. That's striking. And I don't know whether it's because maybe perhaps judges weren't really focusing on it before, and I'm hoping now that this is an eye-opener for the members of the judiciary to say, oh, wow, and start to look and start to notice and give opportunities, such as Judge Weinstein does in his rules that I read earlier, give women and junior associates, regardless of gender, the opportunity to speak, and maybe have more than one speaker during the argument of a motion, more than one attorney questioning different witnesses during a trial, depending upon whether or not that attorney has worked with that witness. And as Carrie said earlier, sometimes an associate may know a file better than a senior trial partner because they're the ones who are dealing with it on a day-to-day basis. So I think that would be a good thing if more judges could amend their rules, such as Judge Weinstein did, to allow for that opportunity to teach and mentor the younger lawyers.
I mean, I feel like I had this experience as a younger associate, and I'm sure you observed it as well. And on the bench, is you see younger associates passing notes to the senior partner, or sort of frantically trying to get their attention, or even sometimes the pained expression as the partner's speaking. Mm-hmm. And those are all just clues, right? I mean, it doesn't mean certainly that senior partner may be way more experienced. And, having the younger attorney, again, that's going to entail some risk for everyone involved because there is a learning curve here. But again, going back to the client perspective, we just really need to shift the way that we are thinking about it, because as long as we are only ultimately comfortable in the biggest situations, even the smallest parts of the biggest situations, having a certain profile person speak because we believe that based on experience that that's the best person, I think it's going to be really hard to make meaningful progress. Some of the sort of little things that I often will try to do on this point in a more kind of low-key situation is if I'm having like a regular call in a particular matter with outside counsel team, I try in the beginning to set up the expectation that there should be a younger lawyer leading that call, right? There's no reason that the younger person on the team can't run the agenda on a monthly call in a matter, right? That's a lower risk situation, but it gives that attorney confidence. It gives them exposure before the client. Same thing about in-person meetings. I try to set the expectation that if you're going to come to a meeting and I'm going to pay for your rate to be there, you need to participate and you need to be, adding something. And so I feel like when I was in private practice, I went to so many meetings as a young lawyer where I didn't feel like I could say anything. And I actually don't know what would have happened if I had said anything. I mean, over the years, you become, you get to know people and you get to know matters. But I feel like when that dynamic starts, again, to kind of this idea that if you haven't stood up in court after a certain number of years, it's tougher, that same dynamic, I think, makes, younger, female, more diverse attorneys less inclined, and then it also gets harder. So again, I feel like there's more to be done on the client side as well, because most of the time, right, when you as a client set that expectation with the partner, they're not going to disagree, right? They're going to, encourage their team members to speak up, even if it may not be what that partner would have done otherwise. So again, I think these initiatives that some of the bigger companies have put in place, the Mansfield rule, for example, which is sort of a percentage of women and diverse attorneys in leadership positions, all of those initiatives are great, but I also always come back to sort of the practical choices that we make on a day-to-day basis and recognizing how we can ourselves move the needle in a little bit of a way.
Judge Bonina, how do you think we could move the needle in high-stakes, complex cases for women to have more opportunities in ADR?
As neutrals or participating as representing the clients?
As participating, representing clients.
Again, I think it's part of the whole mentoring process and bringing them in and making sure that the women have that opportunity to whether participate in the negotiations or to ask some questions during an arbitration. I think that's really important, because we can't get experience unless we get the experience, right? We have to be able to allow women to speak, to ask questions, to negotiate the cases, and bringing them in maybe under the supervision of a partner, a senior partner, or the senior trial attorney, and letting them get their feet wet is the only way to learn, really.
How did you make the transition from the bench to a private ADR?
It's so long ago, it's hard to remember. But I left the bench and I was offered an opportunity here, and it was great, but it was quite a transition. It was because it's very different from being on the bench, for sure.
But I know that you pursued it and you became, you're so busy. You're busy every single day of the week, and you're in great demand. What do you think are the qualities that you have that help you to be in such great demand?
Well, it's interesting, as Carrie said earlier, sometimes women have that certain natural abilities to perhaps organize and foster teamwork. And what I think of myself as certainly as a mediator is that I'm a professional peacemaker. That's how I like to see myself. We're here to make peace, whether and by peace I mean settling a case, resolving a dispute, right? Resolving a dispute is making peace. And in ADR, and at least in the cases I deal with, it's about a monetary settlement. And I think that as a woman I can bring that perspective to it and keep everyone calm when otherwise maybe we might have someone who might not be as calm. Let me put it to you that way. So I do like to think of myself as that professional peacemaker and try to, keep everyone positive and moving forward in the right direction.
And how do you keep the calm during?
Sometimes it's not easy.
Okay.
But I think that sometimes with just a little joke or I try to make sure everybody, again, maybe it's just being the Italian mother sort of thing. I say, mangia, when I serve food, I bring in food, I bring in water, make sure everybody's well fed, everybody's eating and drinking. Because sometimes that can just help break the ice a little. Maybe make a little joke like that. Oh, mangia, it's time to eat now. Let's get everybody some food, and it kind of breaks the ice and kind of keeps everyone. Reminding everyone that we're all humans, and it's we don't have to worry about the big try not to be the big personality sometimes, and just instead try and just foster good conversation, and through conversation we can sometimes find a way to achieve that settlement just through calm conversation.
And what do you do when things get combative, Carrie?
Good question. I think I certainly adopt a similar approach that, taking a step back, trying to sort of put in the brakes to sort of put a natural end to an emotion and let someone, take some deep breaths. I think, though, that the other thing that from a female perspective in those situations that this is where some of the stereotypes come in. I'm a very straight shooter, and I try to do it in a way that's appropriate and it is without emotion. But there's sometimes a perception there that is a negative perception if you're a female and you're doing it that way. And so, but at least from my perspective, I feel like that's not it's not a negotiable piece for me, right? I'm not going to try to sort of smooth over the delivery because I want to be, I want to keep it sort of a calm conversation, but I also think, we as women, need to maybe learn to do that a little more, right? And not to be afraid that it's going to be poorly perceived, because you see it happen. I see it happen in the business environment frequently, where I see men saying things that sometimes I say, oh, I can't believe he said that. And actually, it was perfectly appropriate that he said that. And, should I hesitate to say that because I worry how someone will perceive me? I think people have different, this is kind of a controversial area, people have different thoughts on it. But I feel like we just have to get over that in some respect.
Judge Benina, what do you do when situations like that come up where you feel that it's inappropriate of what someone might have said?
Well, in a nice way, and I try never to lose my cool. First of all, I think I'm known for not losing my cool, but I think in the nicest possible way, pointing out that what was said was completely inappropriate. Someone said to me in a mediation probably about 6-7 months ago when I brought an offer in, and a gentleman said, if I'm going to spit all over that offer. Well, what do you mean? Excuse me, you know, like, and just really start screaming. I'm like, hold on a second. This is not personal. This is not a personal thing. This is a first offer. We have many hours to work together. Let's try to, you know, take the negativity out of this and say, how do we respond to that and show that that's not, you know, how would you want to respond to that to show that it's not an offer you were hoping for? But we have to do it in a, you know, a calm, professional way, and don't start, you know, telling me that you're going to, quote unquote, spit all over something. You know, it was just so inappropriate. I just really want to shut that down. But again, calmly, nicely. I think sometimes when people have raised their voices, sometimes, you know, and sometimes things do get very heated in what I do. I'll say sometimes I don't know if you realize that you're raising your voice. You know, I don't know if you realize that, you know, you're acting inappropriately, and just in the nicest way possible, but shut it down. You know, again, I think maybe I speak softly, but try to carry a big stick sort of thing, but I do shut it down.
You know, I also agree that you, with the, you know, even on this topic, right, when you are seeing people say or do things that, you know, you feel like either maybe inappropriate or they certainly aren't supportive of a younger or a more diverse attorney, you know, I think you just have to, you do have to say something, and you don't have to do it right in the context of a full group, but I think it kind of goes back to this implicit bias point, right? It's not because you're addressing an issue that, you know, you might have a male colleague have made a comment, it doesn't mean that you know, you're subscribing any ill motive, but I think that in the very appropriate way, not to belabor the point, but to address that, you know, you made that comment, I'm not sure if you realized it could have been perceived this way, or did you notice that after you said that, this person didn't speak at all later in the meeting? You know, I feel like that's something that we often shy away from as women, and I think it doesn't do us any good to not address those situations in the moment.
So where do we go from here? We're going to take some questions from the audience in a few minutes, but right now, how do we move the needle, and where do we go from here, Judge Benina?
Well, that's a great question. I think that we need to, first of all, I think awareness is the first part of it. The survey is, again, the results of the survey are striking. It's true. Now that we're aware that there is this issue and we have some challenges, we need to face it head on and bring younger people in, men, women, bring the younger people in, allow them to have those opportunities. I think Judge Weinstein, again, I go back to his rules and his part, you know, allowing younger associates, younger attorneys to speak, giving them those opportunities, bringing them to an arbitration, bringing them to a mediation, allowing them to question a witness or allow them to sum up or make the opening statement. I think that's really key is to mentor, bring people up and behind us and, you know, and help them learn. That's the only way they're going to learn. So I think that's the thing is now that we're aware, what do we do about it? And I think that the best way to do something is by mentoring and bringing the younger attorneys in and allowing them to have those opportunities to speak.
I think we're going to take the questions from the audience. We have many questions. Kelly, I'll let you give the first question.
Sure, yeah. We have several great questions that have come in, really good engagement from the audience. The first one is, and it's really a comment for your thoughts, is I am an older attorney who has experienced the benefits of diversity experiments in the 1980s. Based on what I'm hearing today, it is also familiar with the exception of one thing. That is the vulnerability being expressed by the speakers. And they say, back in my days, you acted tough and almost mimicked the men. Today, the speakers are allowing women to be themselves, even scared if we are. What are your thoughts on that?
I mean, I would just say I'm a big believer in being who you are. I'm a big believer in you build off of your natural strengths, and we all have weaknesses, and that's fine, and we have to, I think sometimes we as women, we focus so much on our weaknesses instead of building off of our strengths. And that gets to your point. We try to become something that we're not, and that's never going to work for us. And it never works, even in the context of litigation. When you go into a courtroom, you can't pretend to have sort of a different style than who you are. So I think it's a good thing to the extent we've moved to the point that we feel like we can be more of our authentic selves. But I also think we as women have to recognize that those are strengths you can build on. Going back to sort of, if you can organize 200 contract lawyers doing a document review, you can handle a deposition, I assure you, and you need to sort of have the confidence to understand that that is a transferable skill you can build upon instead of just trying to mimic the style of, say, the biggest and best trial lawyer you see at your firm.
Mm-hmm. I can't agree more with you. That's absolutely correct, to be who we are and not try to be someone else. And, whether I, keep calm in my room one way and a male colleague of mine might do things differently, but at the end of the day, if we're both settling our cases, it's our process and how we do things. So I agree, being ourselves, being true to ourselves, and being the way we are can be our own strength. We can recognize our own strengths and use those. So I agree with you 100%, Carrie.
Great advice, yeah. Okay, the next question is here. You keep saying younger attorney. I presume this is referring to years of experience and not age, per se?
Yes, yes, absolutely. In fact, I had a gap of 5 years between college and law school, so I was often lumped into the young lawyers group in some of the bar associations when I didn't view myself as a young lawyer. So yes, I do. At least I do mean it in terms of experience and not age.
Yeah, for sure.
Okay, great. Another question here: how can we train women in law school to be prepared for the gender bias that still exists in practice? And then a second part to that question is, how can we create more meaning in the practice of law that will encourage women to stay?
That's a tough one.
That is
I think, it's just a very practical thing, right? I mean, it's not that you grow up as a woman and then all of a sudden you enter the workforce as a woman, as a lawyer, and things are dramatically different, right? Like, you have to appreciate that the experiences that you have as a woman there are going to be some similar experiences once you enter the workforce. I mean, from my perspective, I think recognizing that there are certain biases that exist is important, but I also feel at the same point to fixate on that, again, just doesn't get you anywhere, personally speaking. And I just think that, yeah, you don't want to be sort of caught off guard, and you want to sort of know how to deal with these inappropriate situations, right? Because there are inappropriate situations, and I'm a big believer that those should be addressed. But at the same time, I think that if you focus too much on the bias, again, you need to focus on you and what your strengths are and how you build that.
I agree. I agree. I really can't add anything more. You said it so perfectly, Carrie.
Great. Yeah, I mean, another question here kind of talks about how to address those types of situations. Someone asked, how best to respond to negative comments from male counterparts during litigation, ADR, et cetera. If no one steps in to assist, should you ignore or respond with, I don't appreciate your comment, or respond with, are you done? Can we move on? What kind of suggestions would you have for a situation like that?
Well, I don't think it's ever good to ignore something like that. I think, again, a nice way while making a point is, are we done? Can we move along? Or, that's not appreciated. Something said in an appropriate fashion like that would be a way to handle it, at least from my perspective. If you're an attorney, if you're in my position as the neutral, as the judge, I might be able to say something a little bit more than that. But I think that as an attorney, I think that I don't know, Carrie, maybe you disagree with me, but I think as the neutral judge, I can say a little bit more, shut it down, quickly, but quickly. But I don't know, Carrie, how would you handle something like that if as an attorney?
I think I've taken different approaches, and none of them make me feel great. I mean, there have been times where I have totally ignored, and I think there's some times where that's probably the right thing because, it's not unlike my young son who says things to get attention, right? Mm-hmm. But at the same time, I've also made jokes about it. So there have been times where I feel like an inappropriate comment's been made, and I'll sort of make a kind of a joke, a dramatic example to show that that's inappropriate. Honestly, I have to say I didn't think that that was the right approach either. I do think, often it's having that conversation in the moment, and honestly, it's not normally as bad as we think it's going to be, right? I think sometimes we build these things up, and not to say that it's going to take care of the situation and that it's not going to continue, but I think ultimately we have to be prepared to have those tough conversations. I mean, we can't sit here, for an hour talking about the challenges of women, succeeding and not be prepared to have a short, tough conversation. I agree.
Very interesting. So we have about 4 minutes left. We'll squeeze in one more question. And that question is, what can in-house counsel do to ensure that diverse neutrals get selected to serve as arbitrators on their cases? And what impediments are there to selecting women as arbitrators?
That sounds like a question for you, Carrie.
Well, I'll say I don't have a lot of arbitration and mediation experience. I will say, though, a couple of recent experiences I had where the qualified arbitrators, because it was an international dispute, there were no women available. And the more I've learned about that situation, it's a very small sort of club, and I think that's a problem. However, I did have a mediation recently, and it was I did push to have a female mediator. She had an incredible reputation for this particular type of case, and so I have to say I went with that. But to your point on how calm, it was a very emotional situation, and the calmness of her as the neutral, I am convinced, made that mediation so different than some of the others that I've participated in. And so, again, there are and I don't think we should shy away from the fact there are qualities in female neutrals which are different than some male neutrals, and given the situation, that can often be the better choice.
Yeah, I really can't add anything to that since I've never served as an in-house counsel, but I do agree with you that there are times when having a woman as either the arbitrator or the mediator can actually help the situation tremendously. Sometimes I've had to deal with children who have been injured or injured in some sort of situation, and having to look at a scar or talk to the child. I think sometimes counsels feel it may be better to have a woman because the child may feel a little more comfortable with a woman as the arbitrator or the mediator as opposed to a male.
Okay, excellent. Well, we have just about reached the top of the hour at this point. Thank you very much, Judge Bonina and Carrie, as well as Stephanie, for all of your insights today, as well as Law.com for their support. We'd like to thank everyone, of course, for joining us. We hope this discussion was useful to you. Just as a reminder, all participants will be prompted to complete an optional evaluation form, which will ask you to enter the CLE code, and you will then receive an email 1 week from today with instructions on downloading your state-specific CLE certificate. You will also receive an email notification when the archived webcast is available for reference. And with all that said, thank you again, and have a great afternoon.